Good evening, ladies and gentlemen. I'd like to call this Committee of Adjustment meeting held on November 25th, 2020, come to order at 7 p.m. May I have a mover and a seconder, please? Moved by Kennedy, second by Vanderweilen. All in favor? Carried, thank you. Are there any disclosures of pecuniary interest this evening? I see none, thank you. Committee of Adjustment minutes dated October 28th, 2020 be adopted as presented. May I have a mover and a seconder? Moved by Vanderweilen, seconded by Webster. All in favor? Thank you. Application. So welcome to the Committee of Adjustment meeting. Welcome to this Committee of Adjustment meeting to allow the public an opportunity to express their views in regards to the proposed minor variances and consents within Springwater Township. Each applicant and their agent, if applicable, will be given the opportunity to present the applications to the committee and public. Additional information on each of the applications, including any presentation materials, is available in the committee agenda on the Township website. Following those members of the public who registered to make oral submissions prior to 4:30 p.m. yesterday, November 24th, 2020, will be given the opportunity to do so through the Zoom application. All oral submissions will be included in this meeting's minutes and form part of the public record, including the names and addresses of the speaker as information collected under the Municipal Freedom of Information and Protection and Privacy Act. The minutes of the meeting will be posted on the Township website. All comments or questions should be addressed through the chair. I'd ask the Secretary Treasurer now to please introduce the first application, item 4.1.
Minor variance application A1220 submitted by M. McKechnie, owner of lands known municipally as 75 Trail Boulevard. The purpose and effect of this application is to permit the construction of a covered deck, 56.7 square meters in size, and a detached accessory building, 35.7 square meters in size, on the subject property, which will result in a maximum lot coverage of 38.5%, whereas the bylaw permits a maximum of 35%. This application was originally deferred on October 28th, requesting additional information from the applicant.
Thank you. Has there been any additional correspondence and/or comments received?
Comments were received from R.J. Burnside and Associates on November 5th, advising the Soakaway Trench can be realigned to accommodate the proposed design. On November 19th, the Building Department advised that they are satisfied with the comments received and have no objections. November 25th, the Director of Public Works advised that the property is located in a subdivision not fully assumed by the Township.
Thank you. I'll have the applicant or their agent state their name and advise us of your intentions, please.
Hello, am I live at this point?
Go ahead.
I think, okay, there, I had trouble getting unmuted for a moment. My name is Mike McKechnie. As stated, I live at 75 Trail Boulevard. The initial plan for the house was to add a covered deck to help keep the snow away from the back doors, and kind of help with the backyard lifestyle. And there was to be a 12 by 9 shed, but we've had a lot of family moving into the neighborhood. We've had kids ourselves since then, and now it's been suggested by many of our family members that we should be adding a pool, and I agree. So if we can do that, we're going to go through the building permit process and obtain all that stuff to do the pool. But in order to do the pool, we're going to need to grow that shed a little bit. And in the process of doing my design, I found that I was exceeding the bylaw requirements of 35%. So I have asked for an exception to that variance to attain 38.5%, which is slightly more than I anticipate I'll require, but I just wanted to be assured that in the event the architect designs it the building code requires certain things, that at least I'm not going to have to come back to you for a second variance.
Thank you. Are there any members of the public registered to make any oral submissions?
Thank you, Chair. No members of the public have registered to make an oral submission.
Thank you. Any members of the committee have any questions or comments? Seeing none, I have a motion here. Who wants to, Lauren, moved by Cooney, seconded by Vanderweilen. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question, and its surroundings as addressed in the planning report on the application dated October 28, 2020, correspondence received and information presented at the hearing held on October 28, 2020, and November 25, 2020, and the discussion on the matter hereby approve application A1220 as applied for. All in favor? Carried. Thank you, sir.
Thank you kindly. Have a good evening.
Secretary, ready to move or introduce item 4.2?
Minor variance application A1420 submitted by D&S Grotto, owners of lands known municipally as 14 Park Trail. The purpose and effect of this application is to permit the construction of an in-ground pool partially within an interior side yard on the subject property, which will result in a decrease to the minimum interior side yard setback, as described as being a setback of 1.2 meters, whereas the bylaw requires a minimum setback of 7.5 meters.
Thank you. Has there been any additional correspondence or comments received?
On November 17th, comments were received from the building department advising that they have no concerns with the application.
That's all? Thank you. Can I have the applicant introduce themselves and present their application, please?
Yes, good evening. My name is Susan Grotto. I represent my husband, Don, who unfortunately is working. We live at 14 Park Trail, as mentioned, and we would like to put an in-ground pool onto the property. It's in the northeast corner or side of the house where we'd like to put it. And the reasons are because, as you know, Midhurst is full of beautiful trees and vegetation, and it's the only area on the property where we can put the pool without disturbing any vegetation whatsoever. So because it is on an interior sidewall, the minor variance is needed, and we're hoping that this is something that can be approved. The idea was to ensure that no vegetation was disturbed, as well as making sure that our neighbors, of course, were okay with the setback to their property. The properties on Park Trail, there's quite a distance between them. There is about 42 feet between our property line and the neighbor's home. So we felt this might be the best spot for the pool.
Thank you. Are there any members of the public registered to make any oral submissions relating to this proposal?
Thank you, Chair. No members of the public have registered to make an oral submission.
Thank you. Any members of the committee have any questions? Go ahead.
So there will be a privacy fence put up? It's got to go through the building department?
If I may respond to you, the swimming pool bylaw requires that they have a fence. Any other questions, concerns? I have a motion. Anybody wish to move it and second it? Moved by Kennedy, seconded by Cooney. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question, and its surroundings as addressed in the planning report on the application dated November 25th, 2020, correspondence received and information presented at the hearing held on November 25th, 2020, and the discussion on the matter hereby approve application A14/20 as applied for. All in favor? Carried. Thank you, Mrs. Grotto. Your your application has been approved here. There is a 20-day appeal period.
Thank you very much. Have a good evening.
Ask the secretary to introduce item 4.3, please.
Minor variance application A1520 submitted by SNR Johnston, owners of lands known municipally as 32 Beverly Street. The purpose and effect of this application is to permit the construction of a deck 25.39 square meters in size on the subject property, which will result in an increase to the maximum lot coverage as described as being a lot coverage maximum of 38.74%, whereas the bylaw permits a maximum of 35%.
Thank you. Is there any additional correspondence or comments?
Comments were received from the building department on November 17th, advising that they have no objections to the application. On November 25th, the Director of Public Works advised that the property is located in a subdivision not fully assumed by the township. This afternoon, the Nottawasaga Valley Conservation Authority advised that they have no concerns.
Thank you. May I have the applicant introduce themselves and explain their situation, please? Moderator, do you have an applicant online?
Sorry, you were muted. Go ahead.
Hi, sorry, it's Scott Johnson and my wife's here with me, Rosalind. And we had no access to the back other than going out the front door and walking around because the builder left us with a 3-foot drop to the bottom. Both of us I have serious back problems and knee problems, and my wife has 2 bad knees. So instead of steps, we decided we would get a deck out there. We got a deck and we try to keep it inside the footprint of the house in general. So there's no, we didn't increase or decrease the distance to the back of the lot or to the side of the lot. It's in an alcove in the design of the house. And we had no idea at the time that we would have to get a permit. And when we found out, well, we were willing to go along with whatever they needed to do.
Our neighbor doesn't.
Thank
And
you.
our neighbor doesn't object. She has to stand up on a chair to see their deck. And nobody from the street can see it. So it's totally covered. Behind us is the trail, the Trans-Canada Trail. And between us and the trail is a swamp and bush area with all kinds of lovely birds there every summer, which we like to sit out on the deck and watch.
To the left is the water.
And yeah, we're the other side of our house is the water collection for the overflow.
Thank you for your presentation. Are there any members of the public registered to make any oral submissions?
No members of the public have registered to make an oral submission.
Thank you. Any members of the committee have any questions or concerns, comments? Mr. Webster.
Thank you, Chair Gannon. Just as a matter of curiosity, there's an easement. It says subject to an easement, and there is a bit of a little dip in the backyard across there. And it's a bit wet in there. And I don't know what that easement would be. Is there any way we could know, or that the owner could know? Is it a gas line, or is it, does anybody know?
Go ahead.
I could assist Member Webster with that. It's a storm drainage easement that goes through there, and all the water that would come from the subdivision would drain through to the storm pond that the applicant indicated is adjacent their property.
Thank you. Any other questions or concerns? I have a motion here. If anybody wish to move it, moved by Vanderwill, seconded by Kennedy. Have to keep Patty's name on the records here. We haven't seen her for a while. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings as addressed in the planning report on the application dated November 25th, 2020, the correspondence received and information presented at the hearing held on November 25th, 2020, and the discussions on the matter, hereby approve application A1520 as applied for. All in favor? Carried. Your application has been approved, Mr. and Mrs. Johnson. There is a 20-day appeal period. After that time, you can visit the township and get your building permit.
Thank you very much.
Okay, I'll have the secretary introduce item 4.4, please.
Minor variance, application A1720, submitted by W&D Hodgson, owners of lands known municipally as 1249 St. Vincent Street. The purpose and effect of this application is to permit the construction of a pergola with a revised maximum size of 23.15 square meters on the subject property, which will result in an increased maximum total area of accessory buildings and lot coverage than previously approved, as described as being a maximum total area of accessory buildings and structures of 103.44 square meters. Whereas the bylaw requires that the maximum total area of accessory buildings or structures shall be 65 square meters, and the previous minor variance permitted a maximum of 93.65 square meters. And being a maximum lot coverage of 22.1%, whereas the bylaw requires a maximum lot coverage of 20%, and the previous minor variance permitted a maximum of 21.4%.
Thank you. Is there any additional correspondence or comments?
Comments were received from the building department advising that they have no objections with the application.
Thank you. And I ask the applicant to introduce themselves and to present their application, please.
Hello, my name is Albert Sauvé. I'm representing Bill Hodgson for the subject property.
Go ahead.
We would just like to increase our lot coverage for this pergola so that we can construct it in the spring. We built a garage last year and a gazebo, and that increased our lot coverage, so that's why we have to ask for the new variance.
Thank you. Are there any members of the public who wish to make a comment on this?
No members of the public have registered to make an oral submission.
Thank you. Members of the committee, any questions or concerns, comments? Mr. Cooney?
I have two for the applicant. Just to confirm, the previous drawing, indicated the pergola and the gazebo in different locations that are now being proposed, and it also looked like a retaining wall was proposed. And you've now since relocated the two structures a little closer to the property line. Is that clear?
So what happened there is we just rotated the gazebo on a 45-degree angle. And no, we didn't go any closer to the property line. We're still very well within the maintenance, within the rear yard setbacks. And as far as the retaining wall, it was always designed where it was.
I see. So the retaining wall is it's not indicated on the new proposed plan, but it still exists.
Yes, it
Okay.
does.
Okay. Thank you.
Thank you. Any other questions or comments? Seeing none, I have an application. Moved by Webster, seconded by Vander Wielen. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings, as addressed in Planning Report on the application dated November 25th, 2020, correspondence received and information presented at the hearing held on November 25th, 2020, and the discussion on the matter, hereby approve application A17/20 as applied for. All in favor? Carried. Thank you, sir. Your application has been approved. There's a 20-day waiting period.
Thank you very much.
Ask the secretary to introduce item 4.5, please.
Consent application B0620 submitted by M. Corey on behalf of the owners of lands known municipally as 2774 Old Second South. The purpose of the application is to obtain approval to sever one residential lot consisting of approximately 22.09 acres of lot area with approximately 412 meters of lot frontage on Old Second South, containing a single dwelling unit and accessory building. The applicant proposes to retain approximately 86.33 acres of lot area, which is subject to a draft plan of subdivision application. 2 easements are to be established over the severed lands to provide for sufficient outfall of stormwater runoff related to the retained lands, which are subject to a pending subdivision application.
Thank you. Additional correspondence or comments, please?
On November 10th, comments were received from the township's drainage superintendent advising that no condition for drainage will be required. November 11th, we received a request to be notified of the decision from Dave Chai of 2809 Old Second South. On November 12th, comments from the township's engineering technologist were received advising that staff should consider the most suitable approach to establishing drainage easements across this parcel of land in order to facilitate the adjacent future development. November 16th, comments from the Director of Public Works were received advising that the subject lands are within a location assumed by the township. Comments were received from the Building Department on November 18th advising that they have no objections to the proposal. Earlier today, the Nottawasaga Valley Conservation Authority advised that they have no concerns.
Thank you. Ask the applicant to introduce themselves and provide us a presentation as to what the application is about.
Thank you, Mr. Chair, and good evening, members of the committee. My name is Cheryl Shindrock. I represent the applicant for this severance application, which is a Geranium company. Geranium is the developer of the lands adjacent to the proposed severed parcel. I am accompanied this evening by Mr. Matt Corey, a professional land use planner, and Mr. John Priamo, a professional civil engineer. As set out in the staff report before you, we are here to request a severance from the property located at 2774 Old Second South in the Midhurst settlement area. The staff report is comprehensive and accurately reflects our application. As I noted, we are the developers of the plan of subdivision, which is depicted in the report on page 3 and also in the appendix to the staff report. And as you can see in that figure, the parcel that is proposed to be severed has always been excluded from the plan of subdivision and not intended to be developed. It is intended, though, to be maintained as an existing single detached dwelling. As the subdivision is not yet advancing through the approvals process, and there is a desire for these lands to be legally severed from the subdivision lands for estate planning purposes, we are here today asking for the committee's consent to allow the severance. I would note that we support the conditions that have been set out in the staff report, and we would ask for the committee's approval as recommended by staff. At this point, we are happy to answer any questions the committee may have.
Thank you. Give me a second here. Are there any members of the public registered to make any oral submissions relating to this proposal?
Thank you, Chair. There are 2 members of the public who've registered to make an oral submission.
Can we go ahead with the first one, please?
Yes, the first commenter is Aaron Attenrich. Aaron, you may go ahead.
Hi there, can you hear me?
Yes.
Go ahead.
Okay. We are currently renting the property at 2774 Old Second South, and we just wanted to be here to be part of this proceedings because we would like to live here forever. We absolutely love the location and the home. We don't intend on changing much other than aesthetically. There's really not much more to say than that. We really, really hope this severance goes through because we never want to leave here.
Thank you for your comments. We have the next party, please.
Thank you, Chair. The next commenter is Rick Jones. Just a minute here. Rick, you may now address the chair and committee with your questions or comments.
Thank you. Cheryl described the situation perfectly well, and Aaron is an individual I've known for about a year who rents the house from us, and her desire to live there is a genuine one, and we'd like to make that happen if we could.
Thank you for your comments. Members of the committee, do you have any questions or concerns? And we'll start with Member Kennedy.
Through you, Mr. Chair, to staff. I'm just wondering if you could clarify for me, in the background of this report, you say that the lands are located within Neighborhood 3 of the Midhurst Secondary Plan area and are partially designated for future subdivision development. So which lands are partially designated?
Staff?
Thank you, Mr. Chair. Through you to Committee Member Kennedy. The lands that are designated for urban development would be the retained lands. Those are the lands that have been set aside and are subject to the active applications that were mentioned by Ms. Schindrick.
Thank you. Any other questions? Member Cooney?
Thanks, Chair. My mic isn't working. I just have a question for staff as well with respect to the two easements. Just want to clarify that the easements would be continuous across the property for the purposes of drainage. And the second part of that question would be, how would they be, the width of the easement be determined?
Lauren, can I ask you to use the other microphone because I don't believe Director Sprague heard any of your comments or questions.
Can you hear me now? Okay, thank you. The first part of the question I had was with regards to the easement, and just to clarify, the easement would be continuous across the entire parcel of land that's being severed from its entrance, the drainage entrance from the storm ponds to its exit to I think it's the adjacent property to the south. And then the second part of the question I have is, how will the width of the easement be determined? Is that done by the staff or the Nottawasaga Conservation Authority?
Any concerns or?
Thank you, Mr. Chairman. Through you to Committee Member Cooney. The answers to the first question is that it's my understanding that the easement will travel as you have stated. As far as the width of the easement, the location, all of that will have to be sorted out through the subdivision process. The NVCA will be included in those discussions along with the township engineers. I could turn the question, with your indulgence, Mr. Chair, over to the representatives of the applicant just to confirm that, but that is my understanding.
Thank you. Can you confirm that, please?
Mr. Chairman, it's Cheryl Schindrick speaking here. That would be correct. I would ask Mr. Priamo, perhaps the professional engineer, to comment further on the establishment of the easement.
It's John Priamo from SCS Consulting Group. The easements have been determined to date to be adequately sized to provide flexibility in the future to ensure that the most effective outfalls from future stormwater management facilities can be placed, ensuring that there's no overly restrictive provisions put in place to date. So they've been looked at on a technical basis to ensure that they provide they're in the correct spots based on what has been submitted to date, as well as provide enough flexibility to ensure the most effective solution for the municipality long term.
Thank you, John. And Mr. Chairman, I would add that the onus would be on us as the developers to ensure that we've got the proper outlets secured for the future development of these lands.
Thank you, Member Cooney.
Thank you, both John and Cheryl. I just wanted to I want to clarify, the easements you're talking about are from the storm pond to the existing watercourse. Am I understanding that correctly?
Yes.
So my concern, I understand that component, but there's also the element of the drainage that comes across the severed parcel that still needs to be contained within an easement for the drainage purposes.
Perhaps Mr. Priamo could comment further on that.
Maybe just to clarify what has been asked, the drainage purposes that exist on the property will continue to drain in the current fashion, which is towards the drainage feature that kind of cuts through the middle of the existing property to be severed. There would be no additional easements or modifications required for that drainage.
Yeah, I just want to understand, you're creating easements that come from that outlet from the storm pond to the water course. But from the water course through the severed lands, how will how will the water course be maintained? Would it be the severed land owner's responsibility or the municipalities? And if it's the municipalities, because their drainage will be coming from the proposed development, there should be an additional easement that conveys that water to the outlet of the severed lands as well.
Mr. Priamo?
Once the water is conveyed to the drainage feature, it's considered a permanent water course in that location and therefore is regulated by the Conservation Authority and then would not be allowed to be modified without written consent and permits from the Conservation Authority. So through the discussions to date, that an additional easement wouldn't be required, as no modifications to that would be allowed without permission from both the Conservation Authority and the township.
Go ahead, Mr. Cooney.
Thank you for your information.
Thank you. Mr. Webster.
Thank you, Chair Gannon. I share the same inquiry. I'm still not quite clear the size, the dimensions of the easement, and I don't really see the easement mentioned in our conditions as being either closed or open as to the size and the direction and all that. So I'm concerned that we're not defining the easement for drainage, stormwater management in particular, in a defined way. It seems to be kind of open-ended here. Correct me if I'm not getting this right, please.
Thank you. Director Spragnall, would you like to make comment on this, please? This is your report.
Thank you, Mr. Chair, through you to Committee Member Webster. The conditions are left open because it's a matter of engineering that will sort out the easements as the condition of approval. So essentially what will happen is the engineers will sort out what the appropriate easements need to be, and then legals will take that forward and ensure that the proper easements are established to reflect the engineering for the subdivision and to ensure that there's an adequate outfall for the stormwater.
Thank you.
We haven't gone through the full subdivision process yet, so therefore that's something that the engineers are going to have to iron out along with legal.
Thank you, Director Spragnall, and that's exactly my consideration here is the severed property, which the previous comment was that we want to own this property, but do you want to own it with an easement that's one size, or the easement that's 3 times that size, or that runs through your living room, or I think there needs to be a condition to the severed lands that somehow or other on the new title of the severed lands, the easement is still open to discussion and placement on the severed lands property or on the retained lands property, whichever, whatever. But it seems to be relatively, or to me at least, very open-ended.
Mr. Chairman, perhaps I could, Cheryl Shindrick speaking here again. I would note as well for the benefit of the committee that the engineers have looked at this and are proposing it as what you see in the report, very conservative easement areas. But we also have the consent of Mr. Jones to allow us to put in place the easements that are necessary on a go-forward basis.
Thank you.
That should provide the committee with some additional comfort.
Mr. Webster?
I thank you, Ms. Hendrick, and I understand that. I just wonder if that shouldn't be a condition of the severance, that Mr. Jones recognizes that the size and placement of the easement is still to be determined.
Director Spragnall, you want to make comment on that, please?
Thank you, Mr. Chair. I don't think that there's an issue with that, given that we have Mr. Jones on the call. I'm pretty sure that he could comment as well, but I wouldn't be opposed to that being added to the condition.
We have proposed that the easements, as depicted, are sufficiently generous and conservative to allow for, slight changes that might occur in the topography or the conditions of the land. And so we're confident from a professional perspective in the conceptual easement areas as reflected in the report, recognizing that, we need to finalize this at some point into the future.
And this is John Paramo again, just to piggyback off Cheryl's point there, and maybe I wasn't clear enough originally. The easements that have been proposed to date, we know are sufficiently large to accommodate any modifications to what has been considered to date with respect to proposed stormwater facilities that would need to utilize these easements. We would, we are confident that going forward, they would only be reduced in size. And therefore, as they're currently shown, there doesn't seem to be a need to make a provision for them to potentially be larger.
Hello?
Go ahead, Mr. Jones.
I certainly don't object to a more flexible language if the committee thinks that would provide rather more assurance. I believe the easements are sufficiently sized, but in the event that more is needed, the language of the condition could change accordingly.
Thank you. Member Kennedy, did you have a question or comment?
Just clarification through to either staff or the applicant. So the documents that I have before me, I can't see easements that have been shown on these documents. But I apologize, I don't have my glasses with me tonight either. So has a draft R plan been created for these easements to date?
Mr. Spragnall or the applicant?
Thank you, Mr. Chair. We have not received the draft R plan for the easements as of yet. It would have to be something that would be finalized as per the condition.
Thank you. Member Kennedy, you satisfied? Thank you.
Yes, thank you.
Any other questions or comments? Mr. Cooney?
Thanks. I don't have objection to the application, and I prefer to have the wording for the easement a little bit open or general in that regard, so that if the easement needs to be adjusted accordingly or extended accordingly, then the engineers and the planning staff can do so during the detailed design. That's my comment.
Thank you. Mr. Webster?
I concur with Member Cooney.
Thank you. The item 6 on the motion says that the applicant established 2 easements on severed residential parcel to address storm water management outflows from the proposed subdivision. Is that sufficient, or do you wish to strengthen or reduce that? And perhaps Director Spragnall, you might have some additional wording that might help us out here?
Thank you, Mr. Chair. I think what I heard was that the conditions as outlined would provide sufficient flexibility to allow for the preparation of an R plan and to adjust the easement as needed through through detailed design. So I think maybe the only thing that might need to be added here is that the applicant establish 2 easements to convey stormwater on severed residential parcel. I think, to tell the honest truth, I think condition 6 is worded accordingly where it does provide the needed flexibility to deal with this through detailed design.
Thank you. The way I'm reading it, I see it, is the rest of the committee agreeable to that? Member Cooney?
Can I just clarify with the director, and sorry for this, the establishment of the easements, if you could clarify for me, is done through your subdivision consultant, or your township consultant, and your work staff, as well as your staff, correct?
Through you, Mr. Chair, to Committee Member Cooney, the establishment of the easements will be provided through plans from the applicant, but will be reviewed by Ainley's and township staff to ensure that they're adequate and sufficient to provide for the necessary drainage of stormwater.
Thank you for clarifying that.
Member Kennedy?
So just to clarify for everybody, the stormwater management report from the applicant, from the developer, will size the easement required for that conveyance, and then the township would review that and agree or disagree. At the same time, when they submit their application for their detailed engineering, the draft R plan would be submitted for those easements to be reviewed as well.
Thank you. Any other comments or questions, concerns? Go ahead, Mr. Webster.
Just for clarification, Chair, so at that time, the owner of the 22 acres will get whatever the engineering reports that are satisfied by everybody, that's what they're going to get. If it's the Mississippi River or a 6-inch conduit, they're getting it. Am I correct?
Director Spragnall?
Thank you, Mr. Chair, through to Committee Member Webster. I think it's a matter of agreement from the resident, and that would be the case based on the easement size and what's proposed and what's solidified through the condition. That would be what is provided for as the outlet.
Go ahead.
Thank you. So to be clear, the owner of the 22 acres will get whatever easement it satisfies the engineering for stormwater management, agreed upon by the municipality and by the developer. Is that correct?
Mr. Chair, through you to Committee Member Webster, that is correct. It's also of the understanding that the property owner is agreeing to the condition, and I would think would know what that looks like as part of this process.
Thank you, Director Spragnall.
Any comments, questions, concerns? I have a motion, moved by Cooney, seconded by Kennedy. File number B 06/20, applicant M. Corey. In the matter of the consent application B 0720 for lands known municipally as 2774 Old Second South and legally described as Lot 19, Concession 2 and Part 1 Plan 51R-40744, former Township of Vespra, now in the Township of Springwater, roll number 434101000012400, that the Committee of Adjustment, having given consideration to the applicable provisions of Section 53 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the subject land and its surroundings as addressed in the planning report on the subject application dated November 25th, 2020, the correspondence received and information presented at the hearing held on November 25th, 2020, and the discussions on the matter hereby approve of the application as applied for subject to the following conditions, and there are 6. Number one, that the applicant meet all requirements, financial or otherwise, of the municipality. Number two, that the applicant provide 2 copies of the registered survey of the severed lands prepared by an Ontario land surveyor. Number three, that the owner applicant satisfy and be responsible for all costs to satisfy Section 65 of the Drainage Act 1990, if applicable. And number four, that the retained lands be merged on title with the abutting lands to the north, known municipally as 2680 Old Second South. Number five, that the applicant confirm the existing well and septic are wholly contained within these proposed boundaries of the severed parcel. Number six, that the applicant establish 2 easements on severed residential parcel to address stormwater management outflows from the proposed subdivision. Note, if all conditions of this decision have been fulfilled within 1 year from the date this notice of decision is mailed, and all authorities have so notified the committee in writing, the Secretary Treasurer is authorized to provide a certificate as provided for in subsection 53, paragraph 42 of the Planning Act RSO 1990 CP 13. Before we vote on this, the applicant, is this what you understand to be the conditions?
It is, Mr. Chairman. Thank you.
May I have a vote? All in favor? Carried. Thank you.
Thank you very much.
Thank you. Will I have the Secretary introduce item 4.6, please?
Consent applications B0720 to B1020 and minor variance application A1620 by T. Kual on behalf of the owners of lands known municipally as 5 Glen Echo Drive. The purpose of the application is to obtain approval to sever 4 new residential lots with frontage on Heatherwood Drive. The applicant proposes to retain approximately 9,499 square meters of lot area with approximately 95.1 meters of lot frontage on Bayfield Street North and 98 meters of lot frontage on Glen Echo Drive. The applicant has simultaneously submitted a minor variance application and is seeking relief from provisions of the zoning bylaw, as described as being a minimum lot frontage of 23.7 meters, whereas the bylaw requires a minimum lot frontage of 30 meters and a minimum exterior side yard setback of 6 meters, whereas the bylaw requires a minimum exterior side yard setback of 9 meters.
Thank you. Can you provide us with the additional correspondence and comments, please?
Comments were received from the township's drainage superintendent on November 10th, advising that no condition for drainage will be required. On November 13th, we received comments from our engineering technologist who recommended that the consultant prepare a reasonable use assessment to evaluate the risk of undesirable impacts to downgradient groundwater regime and provided recommendations relating to drainage, sediment and erosion control, measures and tree inventory and preservation. On November 16th, the Director of Public Works advised that the subject lands are within a location assumed by the township. November 17th, staff received comments from the Ministry of Transportation advising that prior to agreeing with the proposed severances, that they require confirmation on the intended redevelopment plans for the retained lands. Also on the 17th, staff received a letter of opposition from Tara DeSouza of 32 Heatherwood Drive. On November 23rd, the Nottawasaga Valley Conservation Authority advised that they have no concerns. A letter of opposition was received from James and Nancy Morrow of 4 Strathmore Place and Mike and Terry Vilema of 3 Strathmore Place on November 24th. The Ministry of Transportation provided additional comments on November 25th, advising that they have spoke with the applicant and would be in support of the application, provided a condition to apply a 0.3 meter reserve along the properties that front Bayfield Street that is free and clear of all encumbrances at no cost to the ministry be imposed. This afternoon, letters of opposition were received from Denise Reynolds of 30 Heatherwood Drive and Laura Simon of 40 Heatherwood Drive.
Thank you. Can I please have the applicant or their agent introduce themselves and go through their presentation?
Yes, hi, good evening, Mr. Chair. Just to confirm, you can hear me?
Yes, we can. Go ahead.
Thank you. Good evening, committee staff and members of the public. My name is Greg Barker from Innovative Planning Solutions. I represent the applicant Windstar Developments, Inc. as it relates to the proposed consent and associated minor variances on lands known as 5 Glen Echo Drive and just described. I understand committee and members of the public have access to our presentation materials on the township's agenda and can follow along with my presentation. I will certainly do my best to indicate when to proceed to the next slide. So next slide, please. The entire land holdings are outlined in red in this slide. They're located at the southeast corner of Bayfield Street and Glen Echo Drive, with frontage on both streets, as well as frontage on Heatherwood Drive to the east, and contains a total lot area of 1.58 hectares. The lands are primarily vacant, though does contain one existing dwelling and accessory structures in the southwest corner of the property, with access from Bayfield Street, and existing vegetation throughout and certainly generally towards the eastern portion of the property. The property is located within the Midhurst settlement area and designated both Midhurst Village and commercial/mixed use within the Midhurst secondary plan. The lands are zoned as residential 1, with a small portion of the property zoned as general commercial or CG, and that's located in the northwest corner of the property at the intersection of Glen Echo and Bayfield. The image on the left of this slide illustrates the current zoning for committee's benefit. Next slide, please. To give committee and members of the public some background on the land holdings, we've shown here on this slide the historical lot fabric, which includes 3 and 5 Glen Echo Drive, as well as 1063 and 1053 Bayfield Street, for a total of 4 separate parcels. The applicant is also the owner of 1039 Bayfield Street, which you can see on this slide as well, which is located just to the south of 1053 Bayfield Street. The applicant became the owner of the entire land holdings on November 9th, 2020, resulting in an automatic merger of the lands, with the exception of 1039 Bayfield Street, which is why it's not included in the application and outlined in red on this slide. So technically, committee, the subject lands are now considered one lot. The proposed retained lands, which I will illustrate shortly, are designated as commercial mixed use in the township's official plan, and these lands are intended to be redeveloped in the future in accordance with the official plan. The township is currently completing a review of the official plan, including a Bayfield Street corridor study, which will ultimately provide the policy framework for the entire Bayfield Street corridor, including the retained lands. And once this is implemented, we anticipate redevelopment of the corridor can begin, including the requirement for future Planning Act applications. The applications being considered tonight by committee are generally limited to the eastern half of the former 5 Glen Echo property, as shown on here. And just to confirm, those lands that we're dealing with this evening, committee, are entirely designated as Midhurst Village. Next slide, please. So the surrounding area and neighborhood located along Heatherwood Drive, Strathmore Place, and Lilac Lane, they generally contain single detached dwellings, as shown on this slide, with varying lot frontages and depths. Lot sizes in the area, there's also a range of lot areas, including from over 3,000 square meters to the minimum requirement of 1,390 square meters. So just to give committee an example, the image on the bottom right of this slide, slide 4, we've identified A, B, and C, and then we've got corresponding images just for reference of the character of the neighborhood. But for committee's benefit, Lot A, the lot under label A, that's approximately 2,000 square meters. Label B, those lots are approximately 1,500 square meters, and label C, they're approximately 1,400 square meters. So just to give you an indication of the immediate lot sizes surrounding the property. The built form in this area and neighborhood, it's a mix of bungalows, split levels, and two-story dwellings with a range of 2- and 3-car garages. This neighborhood is serviced with municipal water and individual private septic systems, along with a rural cross-section, including roadside ditches to convey stormwater. Next slide, please. This slide illustrates the lot fabric proposed by the severance applications, including the creation of 4 new lots and 1 retained lot, resulting in a net increase of 1 lot from the historical lot fabric, along with a 3x3 meter daylight triangle at the corner of Glen Echo and Heatherwood Drive. The lot sizes proposed are approximately 1,570 square meters, with 23.7 meters of frontage on Heatherwood Drive, which is subject to a minor variance application this evening as well. Lot 1 is the lot which has frontage along Glen Echo. It has approximately 66 meters of frontage along Glen Echo. The proposed proposed consent applications, they will facilitate 4 new single detached dwellings, which will be similarly serviced as the surrounding area with municipal water and private septic. It is intended that each home will be custom built, designed, and sited to complement the character of the area, including ground floor areas of between 2,200 and 2,500 square feet, with 3 to 4 bedrooms and 2 to 3 car garages. The dwellings will maintain the required 3-meter interior side yard setbacks for each lot, meaning the minimum space between each dwelling would ultimately be 6 meters or approximately 20 feet as required by the zoning bylaw and similar to the requirements of surrounding lots. At this time, no development is proposed on the retained lands. However, I can advise committee that these lands are intended to be redeveloped in the future in a comprehensive manner with a mixed-use development. And as I noted, would ultimately be subject to further Planning Act approvals through Township Council, including at a minimum a zoning bylaw amendment application and site plan control. Next slide, please. The minor variance applications are proposed to permit a reduced lot frontage of 23.7 meters, whereas 30 meters is required, and to permit a reduced exterior side yard setback of 6 meters, where 9 meters is required. And just to clarify, the exterior side yard setback is proposed for only lot 1. The way the bylaw works and the definition of an exterior side yard, it relates to a yard that abuts onto a municipal street. The interior side yards, we are maintaining the requirement of the zoning bylaw, which is 3 meters. So the 6-meter relief we are requesting would only apply to lot 1 as it relates to Glen Echo Drive. The Planning Act permits committee to consider and approve minor variance applications where the 4 tests of the act are satisfied, as I've listed on this slide. It's my opinion the variances are minor as they do not detract from the ability to provide a suitably sized lot and dwelling in a manner consistent with the area. I believe the variances are desirable for the development of the area as it will round out development in an existing settlement area, making efficient use of infrastructure with a built form that is consistent with the existing estate character. It's my opinion the variances conform to the general intent of the official plan, which directs development to settlement areas, supports low density development in the form of single detached dwellings in this location, and can be appropriately serviced. It is my opinion the variances conform to the general intent of the zoning bylaw as well, which permits single detached dwellings. The development exceeds the lot area requirements, which is critical to ensure private septic can be accommodated and provides a consistent low density built form. While the lots are narrower than the requirement of the zoning bylaw, the lot depths and areas provided exceed the requirements and in many cases exceed the size of some of the surrounding lots and are consistent with the range of lot sizes in the neighborhood. This is an important consideration as often the perception of narrow lots is smaller lots. The proposed exterior side yard setback maintains sufficient separation from Glen Echo, allows for a more efficient use of the lands, and is similar to existing exterior side yard setbacks in the neighborhood without detracting from the character of the area. And through the review of the township staff report, I understand that planning staff are also of the opinion that the variances satisfy these tests. Next slide, please. We completed a pre-consultation meeting with township staff on September 10th for this application. It was at that time where staff indicated it would be premature to submit any development applications for the proposed retained lands along Bayfield Street based on the ongoing official plan update. However, the residential lands are not impacted by that process, and the township ultimately provided a study requirements list to support the applications being considered tonight, all of which have been submitted and available for public review. One item that the applicant prepared, despite not being required by the township for submission, is a tree inventory and preservation plan in an effort to demonstrate which boundary trees would potentially be impacted and therefore would warrant protection through future development. The image on the right illustrates the recommended preservation fencing to ensure the boundary trees to the south are protected at a minimum. And based on the recommendations of staff, additional tree preservation plans will also be required through conditions of approval if the applications are approved, to preserve as many trees as possible once additional details are available. So I just want to emphasize to committee and members of the public that additional tree preservation plans will be a requirement should the applications be approved. A functional servicing report was also prepared, which demonstrates conceptually how the lots will be serviced. So the image that you see on the left of this slide, slide 7, it illustrates the conceptual building footprints of approximately 2,200 square feet with 2 car garages along with a septic area. And again, it is also anticipated that this will be further confirmed through the recommended conditions of approval from staff as well. Next slide, please. From a planning policy perspective, the proposed applications are supported and encouraged by all levels of policy, including provincial, county, and local documents. The applications represent sustainable and efficient development located within the built-up area of an existing settlement area where minimum intensification targets are required. The application contributes to the housing stock in a manner that complements the existing neighborhood, making efficient use of existing infrastructure, contributing to the municipal tax base with no additional expense borne by existing residents. The applications are also consistent with the policies relating to the Midhurst Secondary Plan, which provide direction relating to servicing, land use, and urban design. The applications also satisfy the general lot creation policies of the official plan. Next slide, please. So to summarize, committee, the land subject to the proposed severances are currently zoned and designated to permit single detached dwellings and are located within the Midhurst settlement area, an area where growth, development, and intensification is encouraged and supported. While the variance proposed would result in lot widths that are below the zoning bylaw requirements, the lot depths and areas proposed exceed the minimum requirements and exceed many of the lot sizes in the neighborhood. The lot fabric maintains the ability to facilitate a built form as well as individual septic systems, which is consistent with the surrounding neighborhood. The retained lands, they are intended to be developed in the future following the completion of the township's official plan review, including the Bayfield Street corridor study. This will provide the policy framework for the future development applications. The retained lands, as I noted, will ultimately require at a minimum a future zoning bylaw amendment and site plan control applications prior to any development occurring. It is my opinion the proposed consent to minor variance applications are consistent with and achieve the goals and objectives of the applicable planning policies and represents good planning. And lastly, committee, I just want to advise, we have had the opportunity to review the staff reports on the proposed application as well as the circulation comments. At this time, we have no objection to any of the recommended conditions of approval from staff, understanding that the fulfilling of these conditions will address many of the technical concerns raised by the public. And further, we've also had a chance to review the updated comments from the Ministry of Transportation relative to the 0.3 meter reserve along Bayfield Street. And we have no objection to that condition of approval as well. And just to conclude, also available on the line, Mr. Chair and committee, is Dave Ketchison from Azimuth Environmental. He is available should there be any questions relating to the environmental site assessment and record of site condition that was submitted on the property. So with that, thank you, Mr. Chair. I will turn it back to you.
Thank you for your presentation. Are there any members of the public registered to make oral submissions relating to this proposal?
Thank you, Chair. There are 2 members of the public who registered to make an oral submission. We can start with Amy Coots of 29 Heatherwood Drive. Amy, you may now address the chair and committee with your questions or comments.
Hi, I'm actually joined by my husband, Adam, as well. We were actually hoping that Denise would go first because she has prepared a very good statement we have discussed and she has shared with me as well. We both live quite close to the property that is being proposed to be severed. And our concerns come down to not just the aesthetic of the narrowed lots, but also concerns with respect to water and drainage and preservation of the trees. The lot, I think it would significantly impact not having the same tree coverage in terms of a lot of the just appeal, to be honest, of the neighborhood and the area surrounding it. And certainly having 4 residential lots there rather than 3, there's no way there wouldn't be removal of more trees and more of that vegetation and more effect to our soil and our groundwater. And not to mention that based on the plans, the houses look quite close together in the proposal, with the driveways being relatively close to one another and abutting right against an intersection of 3 areas where our children actually are get on the bus. So it just seems like it would add quite a bit more traffic and busyness to that corner, if nothing else. I'm certain there's more I'd like to say, to be honest. It's quite nerve-wracking. Adam, anything you wanted to add?
We've been here for 8 years now. When we first moved in, we used to see signs for 1, 2, 3 lots. I feel when it comes down to it, at the end of the day, they're just trying to put 4 lots in where 3 lots belong. I truly think it will have a negative impact to our community here. You know, we intend on raising our children here, and we've been here for 8 years and continue many more. I just want to have that Midhurst feel and continue to enjoy the area that we live in. So I just wanted to say that.
And the objection is clearly not on the basis of the square footage of the lots, given that they are, you know, a fair size, but the fact that the frontage is narrowed, causing those houses to be closer together, just doesn't fit, you know, the so-called estate-like lots in the neighborhood here. So I understand that there are other older homes with different structures on the roads adjacent, but as in this immediate area, it doesn't quite seem to suit. I think that's all. I would like to defer to Denise, actually, to go through the specifics there.
Thank you for your presentation. Ask the moderator to introduce the next presentation, please.
Thank you, Chair. Next commenter is Denise Reynolds of 30 Heatherwood Drive. Denise, you may now address Chair and committee.
Thank you. Can everybody hear me?
You're fine, go ahead.
Good. I want to thank the committee, first of all, for the opportunity to speak to this application. I did prepare some written comments, so if you'll bear with me just reading it out. I'd like to say the following. The applicant here is using settlement area increased intensification and planning guidelines to justify one additional lot where storm and sanitary sewage consists in our area, as the planner said, of ditches, culverts, and septic systems. This infrastructure means that the surface coverage, removal of vegetation, the soil type, which is all sand here, and water flow must be considered at further depth than this application demonstrates, notwithstanding the decline by NBCA for an environmental impact study, which I believe they should have requested given the boundary is immediately adjacent to the 4 properties in question on Heatherwood. Pooling at Strathmore, Glen Echo, Heatherwood, which is at the intersection immediately in front of the 4 lots, is an issue with every storm and with every snow melt freeze cycle. Covering these lots with greater than 20% of buildings plus 2- and 3-car driveways for each of them, removing vegetation plus our sandy soil is definitely going to have a significant downstream impact on existing residential. Many homes have sump pumps that run year-round already. About their traffic impact letter, I'm quite passionate about this. This letter uses 2017 MTO data to extrapolate estimated trip generation. 2020 data, which show increased traffic on Highway 26 and more residents working from home, creating additional trips by residents and couriers. The data also does not include public safety data, indicating the number of accidents due to vehicle turns at Glen Echo Highway 26 and Curry Road, where the truck center and sports fields are. The 80 km/h and 4 lanes of ever-increasing traffic has led to death, injury, and vehicle damage. This is a public safety hazard to existing and future residents. What are the numbers of those incidents? And has the applicant done anything to mitigate this, or are they just going to be blindly adding to an existing issue? With respect to the exterior side yard setback, I understand what the planner was just saying and saying the difference between the interior and the exterior. But basing reduction of exterior side yard setbacks on 5 examples from the existing residential, keep in mind those 5 examples are not next to each other. 4 lots right next to each other with reduced yards, side yards, and greater building infrastructure coverage on land currently approved for 3 lots is not reasonable, compatible, and appropriate as suggested on page 12 of IPS's document. In conclusion, respectfully, I would ask that the committee either deny this application as it does not meet all criteria for a safe and compatible variance request, or defer the application to allow the owner to provide more thorough investigation and mitigation of drainage, traffic, public safety, and aesthetics of decreased lot frontage. To grant this application garners the township only one more taxpayer. The risk is the damage created by uncontrolled stormwater runoff, increased public risk due to traffic volumes that have been based on 2017 MTO data, and do not reflect 2020's reality, and aesthetically having 4 small lots with large homes, garages, driveways on land approved for 3 lots is not in keeping with our existing residential. I thank the committee very much for your time.
Thank you for your presentation. Moderator, are there any other comments?
No other commenters registered to make oral submission. Thank you.
Thank you. Committee, obviously there's going to be some questions. Who's going to start? Go ahead, Mr. Cooney.
My first question is to the Director of Planning with respect to Lot 1. I was just looking at the drawings and scaling them off. The 23 meter frontage that's proposed, that seems to be accounting for the daylighting. That daylighting, length of 3 meters should be discounted, so then the frontage would only be 20 meters. Can you clarify that, please?
Through you, Mr. Chair, to Committee Member Cooney, the setback distance, the frontage and the setbacks and whatnot would be gauged by the actual frontage on the property line. So my understanding is the daylight triangle has already been provided, and that frontage actually does provide for the 23.7 meters. I would have to refer it over to the consulting planner, Mr. Barker, to confirm that.
Mr. Barker?
Through you, Mr. Chair, thank you for the question. So the way that lot frontage is calculated is measured at the front yard setback. So it's the width of the lot measured at the front yard setback, which in this particular case is 9 meters. So the 23.7 isn't measured along the street. The 23.7 is measured 9 meters in from that front lot line. So yeah, that's the way that the bylaw and Brent, the director Brent Spagnol can correct me if I'm mistaken. That's my understanding in terms of how the frontage is calculated.
This is correct, Mr. Chair. I was just referring to the confirmation of the site triangle and the scale at which it was done at, but Mr. Barker is correct. That frontage is measured from the setback in, the front yard setback.
So to clarify, the frontage width is determined at the front of the building or at 9 meters back from the actual property line.
That is correct.
So the actual frontage, the frontage on the street is less for lot 1 along the street frontage or the right-of-way, correct? It's actually 20 meters in what I'm seeing. Thank you. The other questions I have are with respect to the retained lots. Can you clarify, Director Spagnol, what mixed use would be proposed on the retained lots? And in considering the MTO's comments, where the 1 foot reserve would be along the entire Bayfield Street frontage, and the entrance for these retained lots and the other lots owned by the applicant, which will eventually merge, is to be along the rear frontage, basically, of the proposed severed lots and then out on the Glen Echo Drive. Is that correct?
Sorry, Mr. Chair, through you to Committee Member Cooney, the last portion of your sentence, you kind of broke up when I was trying to listen to what you were saying there.
My apologies. My mic doesn't seem to be working as good tonight. The retained lands and the other lands owned by the applicant are, from my understanding from the presentation, will become mixed use, which is probably commercial and residential, and hopefully you can clarify that. But based on the MTO comments, where a 1 foot reserve will be placed along the entire Bayfield frontage, and they've indicated that the only access to those properties is at the most easterly portion of the retained lands, all of that traffic will be generated from those lands out onto Glen Echo Drive, which would have an impact on the severed lots as well as the existing development that's there now. Am I understanding that correctly?
Through you, Mr. Chair, to Committee Member Cooney. Yes, so the 0.3 meter reserve would be provided for along Bayfield Street. As far as the type of mixed-use commercial development that could potentially happen on the retained lands, that still needs to be determined. And as per Mr. Barker's presentation, there's a Bayfield Street corridor study which is taking a look at possible uses and potential uses along the corridor. One of the key considerations is access onto the corridor and how to deal with traffic associated with mixed-use commercial uses. So that work has not been completed as of yet. It's a study that's currently underway. The one thing that I will add is that the designations for the mixed-use commercial and the Midhurst Village designation pretty much end at the lot lines as being proposed through the severance. So part of the rationale between, the consideration of the severance was that the residential development represents a transition between commercial, mixed use, and the existing residential subdivision. And then the other point I'd like to make, and just going back to the comment about the frontage being 20 meters, if we go back, we measure back 9 meters from the lot line, from the front yard, from the frontage of the property, the measurement of the frontage would be 23.7 meters. As far as the impact of the traffic to the proposed residential, I can't necessarily comment on the impacts of traffic because that traffic work hasn't been conducted to take a look at any prospective uses on the retained lands at this point. As I said, that's all to be covered off through the corridor study to determine appropriate access points for any mixed-use commercial development along the corridor.
Thank you. And I have one last question. The creation of 3 lots here would comply with the Midhurst settlement guidelines if they were to move forward with 3 lots instead of 4. Is that correct?
Through Mr. Chair to Committee Member Cooney. Yeah, 3 lots would definitely comply with the residential R1 zone. However, when taking a look at the Midhurst Village designation, the designation speaks to the word 30 meters as a general guideline for what the frontages may be within that designation. So, based on the wording of the official plan, it appears that there's it's not an absolute number from an official plan standpoint, which is why the severances are being applied this way.
And thank you. I understand that they're general. I just wanted to make the point that they are guidelines and they provide buffers for the estate residential to the mixed use and the highway designations. I just wanted to make that point forward. Thank you.
Thank you. Mr. Webster.
Thank you, Chair Gannon. Through you to Director Spragnell. The corridor development study, is that being done by the Ministry of Transport or who's the author of the corridor study?
Through you, Mr. Chair, to Committee Member Webster. The author of that study is WSP, who is a planning consultant working on behalf of the municipality for the official plan review process. The Ministry of Transportation has been notified of the study on a number of occasions and will be involved directly in commenting and in dialogue with respect to that study.
Thank you again, through the chair. Having the opportunity to go in and out of Curry Drive occasionally, I can certainly attest to the trepidation that the folks on Heatherwood, et cetera, in there have. That's not a that intersection is busy, and it's 4 lanes north and south, and I know the traffic in and out of Curry Drive is a very, very busy truck dealership, as well as the sports field there, and as well, Curry has a development proposal of some nature underway in the lands behind there, which is a large parcel of land, which I would assume will attract even more development and more traffic. My guess would be that at some point in time, that intersection will have to be a light of some nature there, a controlled traffic entrance on both Glen Echo and Curry Drive. So I'm not sure that in the long term that there won't be some kind of traffic control signal there. And perhaps you could comment on that for me.
Through you, Mr. Chair, to Committee Member Webster. In my experience, and this isn't to say that this is never going to happen, but I know the Ministry of Transportation tries to stay away from placing signalization within their corridors. That's not to say that this will never happen along this corridor because of the busyness of the corridor, but it's something that would have to be broached and discussed when we're consulting with the MTO through that corridor study.
Thank you. I just also would like to ask, the Ainley Group has commented, I'll just read it, a reasonable use assessment to evaluate the risk of undesirable impacts of groundwater regime. with reasonable guidelines, I would assume that that would be, if we granted 4 severances here, that would be part of their, of the approval?
Through Mr. Chair to Committee Member Webster, that is correct. That is not something that we're suggesting or recommending as part of a development agreement. That is something that we're recommending as an outright condition of approval to ensure that the sites can be adequately serviced through sanitary, but also to ensure that from a reasonable use standpoint, nitrate loading and that sort of thing is contained within the envelopes of the properties.
One more follow-up would be the last paragraph of the Ainley report says the tree inventory and preservation assessment recommends clearing of all on-site trees and installation of tree preservation fencing to protect mature vegetation near the adjacent houses. I'm not familiar with what tree presentation fencing is. Could you elaborate, please?
Through you, Mr. Chair, to Committee Member Webster, tree preservation fencing, to tell you the honest truth, that's a new term as far as I know. My understanding is that the township would be looking for some sort of buffering to try to maintain some of the trees on the site. So I think that's what they're indicating. And in my discussions with Ainley, that is definitely the context behind our discussions. So really it's looking at an adequate buffer utilizing the existing trees. I might point out that we wouldn't want to just maintain trees that are in poor condition or at the end of life, because those can sometimes end up in being more of a hazard and more of a nuisance than anything. But I think as far as the assessment goes, the idea is to have some sort of a tree buffer to utilize what's there now.
Thank you. So that would be a condition of this, the notion of these severances as well?
Through you, Mr. Chair, to Committee Member Webster, that is correct. Yes.
Thank you.
Member Kennedy.
Thank you, Mr. Chair. Through you, Mr. Chair, to the Director of Planning, I have a couple of questions or comments with regards to this consent agreement that you're recommending. First of all, I just want to confirm that it's very similar to any site development agreement that would typically be required by the municipality for any development with, I'm not sure what it is in Springwater, but I know some other municipalities have 3 lots or more. They require this type of agreement. I'm curious with regards to the timing for this agreement, because as part of this consent application, the conditions need to be fulfilled within 1 year, if I'm correct. And I'm just curious as to whether or not this agreement will be tied to that 1 year timeline, and if the applicant is required to pay for the agreement with the municipality. You've also suggested a confirmation of water capacity in the system, so I'm assuming that you are going to have Ainley's run the town's water model to ensure that there is adequate water. I'll let you answer those ones, and then I have a couple more.
Through you, Mr. Chair, to Committee Member Kennedy. So the first question, as far as the consent agreement, yes, that is a subdivision agreement like document. It's pretty much standard under the similar mechanisms under the Planning Act, which provides the municipality with the authority to go and implement and require that the engineering standards and things listed, such as the things listed in the report, are adhered to. The agreement would be tied to the 1 year time frame, so the agreement would need to be completed and executed within that 1 year, along with the satisfaction of all of the conditions. And sorry, Committee Member Kennedy, if you could remind me of one of the other questions. I think there was one more.
Yes, the question was with regards to costs for the agreement and fees to be paid, whether the applicant would be required to pay a fee to have the township consultant run the water model.
Thank you, Committee Member Kennedy. So all engineering fees, all legal fees associated with the agreement would be the responsibility of the applicant. As far as the capacity with the water, as far as the condition goes, we put that in as a standard condition just to make sure that we do run the check to ensure that there's capacity in the system. However, in my discussions and through the correspondence from Ainley Group, there wasn't any identified issue with capacity, and under normal circumstances and through their review of the reports, they would indicate if there is an issue based on what they know as far as the water modeling goes. But that is something that would be double checked as part of that agreement process.
Thank you. And one other question, the requirement for a hydrogeological report, can you clarify what that report would be to determine?
Through you, Mr. Chair, to Committee Member Kennedy, it'd be, the purpose of that report would be to take a look at the groundwater conditions on the site. That would also be necessary to take a look at whether or not this normal or classic septic system could be supported on the site, or whether or not there'd be the need for any tertiary treatment. In addition, there's also identification by Ainley Group regarding the need for LIDs to deal with stormwater. It would also have to be done to ensure that the soils there are conducive to possibly supporting LIDs.
Thank you. So that goes to my next question. I was disappointed to see that the functional servicing report submitted only addressed water and sanitary, didn't address stormwater management. And I noticed that the Ainley consultant for the town also didn't make any reference to the stormwater management. One of the oral submissions tonight spoke specifically to drainage issues and drainage problems in the area. So wondering, the drainage and stormwater management bullet here, that is a detailed stormwater management and drainage report, or is that just a overall lot grading and drainage design?
Through you, Mr. Chair, to Committee Member Kennedy, it's an overall drainage plan that would take a look at where the stormwater would go. It is not a full-blown stormwater management plan. In Ainley's review, that wasn't determined to be a requirement for this development, and that's really what staff is going by.
Thank you, Director. Just my final comment is just a comment to committee. Further to what Member Cooney had noted, the Section 5.6 of the Midhurst Secondary Plan allows for the consideration of residential parcels generally having lot frontages of 30 meters and a total lot area of 2,000 square meters. Again, that's generally, so above or below that. But this application is not only below in frontages, it's below in total lot area as well. And I just wanted to bring that to everyone's attention. Thank you.
Thank you. Any other comments or questions? Go ahead, Mr. Webster.
Thank you, Chair Gannon. Through you to Director Spagnell, in our 600-page agenda package here for this application alone, I don't know what page it is, page 12, 4.6, page 12. There is a tree preservation detail drawing, and there is a tree preservation fence detail, but I can't read it. And it looks very much like a fence to me, as opposed to a tree preservation thing. It looks like a fence. I don't know if you can call it up on a bigger screen and you can actually take a peek at it, or just what, but it is there, and it very much looks like a fence.
Through you, Mr. Chair, to Committee Member Webster, I think, you know, with the planning consultant on the call, it might be best to get clarification from Mr. Barker.
Through you, Mr. Chair, and thank you, Brent. Yeah, the fence detail, it's very similar to a sort of a sediment erosion control type fencing. So it's sort of a fabric, and really the intent of it is just to have a barrier between, where construction activities would be happening, as it relates to where it shouldn't be happening in order to preserve the tree. So it's sort of that sort of fabric erosion sediment control type fencing, and again, it's really just to provide a visual indication of development on one side versus preservation and sort of a no touch and preserve area on the other.
Thank you, Mr. Baker. If I can suggest to Member Webster, the subdivision extension on Alexander Street in Anton, or Gibb in Anton Mills, I believe that that's what they're referring to. What occurred at the trail, where they put the fence up to preserve the trees closer to the trail, so that construction work didn't interfere with what was there. I believe that's what they consider the
I get
tree
that,
as a
but this
vision.
looks very much like a permanent structure. The drawing looks like a permanent structure, not a piece of fabric. I can't read it, so I'm not sure, but it doesn't look like a erosion control measure. It looks like a fence.
Thank you.
Through you, Mr. Chair, to Member Webster, we can certainly provide that. It is a fence detail, and it would be similar to, I can't confirm, the fencing that was erected at the Marshall subdivision, the extension of Gibb Ave. That's a file that I was involved in as well, and it would be identical fencing to that, which is a standard detail accepted by Ainley Group, as well as the township on other files. And I apologize if the image looks as though it is a permanent fence. I can assure you it is not. It would be installed prior to any earthworks occurring on the site, and then would be removed once those earthworks are completed. Again, just to ensure that those who are in the machines stay away from areas that need to be avoided.
Thank you.
Thank you, Mr. Baker. That's what I was alluding to. That's the type of fencing that I saw in that subdivision. Any other comments or questions from committee? I would just echo what I heard from my colleagues here, that I don't like personally the layout of the new homes with the abutting driveways. I think that Midhurst has a recognition of being larger lots, and that the folks who bought those homes over the years purchased it because they wanted larger lots, and it's a part of the fabric of that community. In certain areas, there is definitely smaller lots, but in that area, as the building inspector many years ago when that was built, I know that that was a desire. As far as the MTO corridor study, I believe that's been going on for a number of years, and from what I recall, they are looking at a fifth lane as a turning lane, so that's going to impact all those properties along Bayfield Street in the future. I don't know when or how, but that's obviously going to have some concern there too. So, I see 3 lots here, but I don't see 4, and I believe that there is some additional work that needs to be done before any approval should occur. With that in mind, I have 2 pieces of paperwork here in front of me. Madam Secretary, can you tell me which one needs to go first, please?
I believe you should have one for the consents and one for the variance. So I would put the consents first.
Okay, thank you. Can I have a mover and seconder for the consent, please? I have no mover or seconder for the consent. Hold on for 1 second, please.
You have both options there.
Madam Secretary, to either confirm or deny this application, do I not have to put it on the floor?
It should be on there.
I only have a carried, not a deferred, or not a, not approval. Okay, so in order for us to either confirm or deny this, I do have to put it on the floor. So is there anyone who wishes to move or second the application?
I move to deny the application. As Member Cooney.
And I second that, Member Kennedy.
Thank you. So moved by Cooney, seconded by Kennedy. And I do have to go through all this legal reading for us to do this officially. File number B0720-B1020, applicant Windstar Developments Incorporated. In the matter of consent application B0720, B0820, B0920, B1020 for lands known municipally as 5 Glen Echo Drive and legally described as Part Lot 14, Concession 4, former Township of Vespra, now in the Township of Springwater, roll number 434101003-20501. That the Committee of Adjustment, having given consideration to the applicable provisions of Section 53 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the subject land and its surroundings as addressed in the planning report on the subject application dated November 25th, 2020, the correspondence received and the information presented at the hearing held on November 25th, 2020, and the discussion on the matter hereby deny the application as the proponent consent does not conform to the policies of the official plan of the Township of Springwater, as well as objections were received from residents. Does that satisfy the members of the committee? All in favor of moving that? Carried. Thank you.
Quick question. How does the applicant, what can the applicant do going forward? I suppose the Land Planning Tribunal would be one, or reapply for 3 lots. Is that the two alternatives? Perhaps we could know that.
Director Spragnall, do you want to comment on that?
Yes, Mr. Chair, thank you. Through you to committee member Webster. The applicant has the ability to appeal the decision of the committee to the legal planning tribunal, land use tribunal. They could come forward and they could reapply as stated by Mr. Webster, or they could let the application and the decision of the committee sit and rest.
Thank you. Committee, I also have another motion here that has to coincide with this one, which can be denied as well. So can I have a mover and a seconder?
I move to deny the variance application as well.
Thank you. Can I have a seconder? Thank you. File number A1620 dated November 25th, 2020, applicant Windstar Developments Incorporated, moved by Cooney, seconded by Webster, that the Committee of Adjustment, having given consideration to the applicable provisions of Section 45 of the Planning Act, the official plan of the Township of Springwater, the characteristics of the land in question and its surroundings, as addressed in the planning report on the application dated November 25th, 2020, correspondence received and information presented at the hearing held on November 25th, 2020, and the discussion on the matter hereby deny application A1620. All in favor? Carried. Thank you. Thank you, Director Spragnall and the applicant, for your assistance this evening. Moving on to other business. Is there any other business to discuss this evening, Madam Secretary?
Yes, there are 3 items of other business to discuss. The first item being the Committee of Adjustment meeting schedule for 2021.
Thank you. Committee, you've all had a look at that. Is there any concerns? None. May I have a mover and a seconder to accept it? Moved by Kennedy, seconded by Vanderwielen. That the Committee of Adjustment hereby approve the 2021 meeting schedule. All in favor? Carried. Thank you. Madam Secretary, go ahead.
The committee chose to appoint a new chairperson and deputy chair annually. As this is the last meeting for 2020, it is now time to appoint the chairperson for 2021.
Thank you. So as was originally stated, this was going to be a one-term or one-year movement, so it would allow other members of the committee the opportunity to take on the role of chair or deputy chair or vice chair, whatever they wish to call them. We didn't have a very long meeting this year, meeting schedule, so I leave it to the committee to make your recommendations as to how you wish to proceed.
I'm good with the status quo.
Any other comments?
Me as well.
Thank you. So I have to have a mover and seconder that the Committee of Adjustment hereby appoints Dennis Gannon as the chair for 2021. Moved by Kennedy, seconded by Vander Willen. I have to fill in the paperwork here. Moved by Kennedy, seconded by Vander Willen, that the Committee of Adjustment hereby appoints Dennis Gannon as the chairperson for the year 2021. All in favor? It's the first time all the hands have gone up tonight. Carried. Do I get a raise? Okay, carry on, Madam Secretary.
This item is now for the annual appointment of a deputy chairperson.
Thank you. Mr. Cooney has been the deputy chair. Are you prepared to stand again, sir?
I was hoping I could nominate Member Kennedy for this position this year.
I would love to have the opportunity, but unfortunately, due to family circumstances, I'm not going to be able to do it this year. I can't guarantee I would be able to be here. So I'm good with status quo if everybody else is.
Is there a seconder to that? Thank you. Moved by Kennedy, seconded by Vander Willen, that the Committee of Adjustment appoints Lauren Cooney as the deputy chairperson for 2021. All in favor? Carried again. Did you want an acceptance speech? Go ahead, Madam Secretary.
So moving on to correspondence items. There are 2 items of correspondence to be received by the committee. The first item being item 6.1, the acknowledgement letter from LPAT regarding consent application BO 320.
Thank you. Can I have a mover and a seconder? Moved by Kennedy, seconded by Mr. Webster. I'm sorry? Correct, you do. So I have to have you two guys do it. It's only a correspondence, so you still can acknowledge that. No? Okay. Moved by Webster, seconded by Vander Willen. That item 6.1B received as correspondence. All in favor? Carried. Thank you for bringing that back to our attention. Go ahead, Madam Secretary.
Item 6.2, Ontario Association of Committee of Adjustment and Consent Authorities is offering fall webinars. A complete list of the webinars and the series can be found on their website. Each webinar costs $38 for non-members. If you would like to attend, please let staff know in a timely manner, and we can make arrangements to register you.
Thank you. Can I have a mover and seconder to receive this as correspondence? Moved by Cooney, seconded by Kennedy. That item 6.2 be received as correspondence. All in favor? Carried. Thank you. Director Spragnall, I see you're still there. Is there any comments that you wish to enlighten us with this evening?
No, Mr. Chair. Thank you for everything tonight.
Thank you. So on behalf of the committee, I think it's imperative that we wish all the township staff the best that they can have for this 2020 holiday season. Thank you for all your efforts this year. It's been trying for us as well as you. Zoom, and this seems to be working. It's not quite as nice as being in person, but it will work. So can I have a mover and seconder to adjourn this meeting? Moved by Webster, seconded by Kennedy, that the Committee of Adjustment meeting held on November 25th, 2020 does hereby end at 20:51 or 9:50 or 8:51. All in favor? Thank you.